could please explain, how are you related to Brian Dillman?
I was his daughter.
You could please tell a little bit to the court about how these incidents have affected you.
So, my name's Eleanor Dillman, and Brian Dillman was my dad, and when I was 15 years old, he was killed. So I'm here today not only to share my story, but to also speak for all of the other children whose lives have been forever changed by the woman that's sitting before you. So Jacoby, Kenneth, Noah, Janae, Amelia, Anaya, and Emery. These are the kids who learned what grief was so too soon. Me personally, I had to see the crash, and I saw the scene, and that image is burned into my memory, and each time I close my eyes, or I fall asleep, or I let my guard down, I pray that I don't have to see it. And yet, I pushed forward. I aced my classes, I became president of several student organizations, I got into my dream college. Everything I've done to build a future, but none of it will replace what I've lost. No amount of success can fill the space that my father has left behind. Every single day, I work hard to make him proud, but because of her, I'll never get to know if I've succeeded. Dad, I hope that I've made you proud. My father wasn't just my hero, he was a hero to our entire community. He was a doctor who devoted his life to helping others. Every single day, he showed up with compassion, with care, and with purpose. He healed people. He saved people's lives. He gave his time, his knowledge, his heart, and asked for nothing in return. He made the world better every single day. And now he's gone. Maybe one day I won't feel a pang of guilt each time that I laugh, or an immediate sadness whenever I smile. Maybe one day I won't internally panic each time I have to get into the car or walk on a sidewalk. Maybe one day I'll get my optimism back, my joy for life. Maybe one day I'll stop feeling like it should have been me. Maybe one day it won't hurt this bad. Since the day that we lost him, we've had no control over our lives, no control over the media coverage, the legal delays, or the emotional weight that was placed on us without warning. We were thrust into chaos, forced to navigate trauma. There's been no justice, no closure, and no voice for us until now. 2 years ago, I saw Miss Anderson for the first time, and that's a moment that I will never forget. I was a terrified 15-year-old girl caught in the chaos of lawyers, media, and grief. And there she was, sitting behind a window in one of those conference rooms out there, smiling and waving at me, as if she had the right to do that. That moment haunts me. It told me everything that I needed to know. Miss Anderson has no regard for human life. If she did, Kiana and my father wouldn't be gone. If she did, we still wouldn't be here begging for justice. No sentence today is going to bring my dad back. It won't give me another Christmas with him, and it won't erase the fact that someday I'll have lived more years without him than with him, or that I'll grow older than he ever got to be. This wasn't just a tragic accident, it was a choice. And because of that choice, my mother lost the love of her life, my aunt lost her brother, and my grandparents had to bury their son. I lost the man who shaped my entire world. My dad was the glue in our family, and though we will continue on, we will never be the same. We will carry the weight of this every single day. We always will. There's nothing anyone can do to make this right, but today, you have the power to take a step towards justice. A few-month sentence is not justice. It's barely a beginning. So please speak for us, speak for my dad, speak for Kiana, for my family, for Jacoby, for Kenneth, Noah, Janae, Amelia, and Naya Emery, for every life that she's changed. Let this be the moment that somebody finally says enough. Thank you for your time and consideration.
Ms. Gatling, how do you know Kiana Burns?
She was my daughter.
Can you tell the court a little bit about how these incidents have affected you?
So many ways. Of course, the kids come first. 4 of them. At the time, the kids were 8, 6, 4, and 2. Or I'm sorry, the baby was 6 months, I'm sorry. So they were little. The 2 oldest ones remember, and they still struggle today. Counseling, weekly counseling, bi-weekly therapy that comes to the school to talk to them. The oldest one has struggled the most because he has the most memories with his mom. They have been living with me since this happened. I adopted 3 of them. The 4th one is with his father. But for the ones that are with me, I see every day how this affects them. Problems in school, fighting, anger issues, bouts of crying and depression and running out of the classroom because somebody made fun of their mom being gone. It's been a whole ordeal, and it's still ongoing, and it's going to be ongoing because they're just not in a place where they can understand why this happened, why this was allowed to happen. But the kids come first, and my life prior to my daughter being gone is gone as I know it. But that's okay, because I want to show them all the grandma love that I can, because they're not going to get any love. That love from your mother can never be replaced. So they come first. You know, it's for me, changed my life in every way. Fighting to get out of bed in the morning, get the kids up, get them ready. I mean, it's a whole lifestyle change in every way. Financially, just everything. And I just want to stress that the two oldest boys, we had a conversation this morning before they went to school, and they knew what today was, and they wanted me to say how mad they are and how they want as much justice as we can get. That's what they want, and I want what they want. I want them to feel like their mom mattered, and I want them to be shown that it's not acceptable. You can't make decisions like that affect other people that you don't even know. So yeah, that's it.
Ms. Kelli, if you know, how old are the kids now?
11, 8, 5, and 3.
How many of them still have memories of this having occurred?
Well, the three boys do. The 3 oldest ones are boys. The little one is a girl. She doesn't have any memory. She was 6 months old at the time. But the three boys have memories. The 2 older ones in particular have the most, because they were at the age when she passed. They were old enough to understand what was going on, and it's just been a daily struggle, especially for the 2 of them. You know, regardless of the counseling and the therapy and the hospitalizations and the medication, they still struggle. I'm surviving. I'm not really living. I'm surviving. That's how I feel.
If I may, who is Sierra Gavin?
Sierra is my oldest daughter.
And is she here yet this morning?
She is not yet here this morning.
And she was driving over?
She was driving. She had to drop off Janae at preschool, so can't drop her off till 8:50. So she's on her way, but she's aware that she may not make it in time. She just has changed her life as well. She moved in with me. You know, she's in the prime of her life. You know, low 30s at the time her sister died, living her life, working her job, you know, and this happened, and I got the kids, and I was overwhelmed, and I wouldn't be able to do this without her. She quit her job. She moved in with me. She is just such a huge part of even why I'm sitting here today. She's gotten me through some dark nights and some scary surgeries and taking care of the household when I'm not able to. So her, you know, her whole life has been upended by this as well.
I am employed as a certified peer specialist with the Department of Veteran Affairs.
And how long have you known Kelli Anderson?
I've known Kelli. I met Kelli years ago when we both attended school at Kentucky State University. It would have been in the mid-'80s.
And do you have a professional relationship with Ms. Anderson as well?
Yes, I do. I have been providing peer mentoring services to Ms. Anderson for the past 2.5 years. I specialize in mental health and traumatology, PTSD, specifically the aftermath of vehicular deaths, vehicular accidents resulting in death.
summarize what you observed with Kelli throughout the time that you had that professional relationship with her?
Yes. From the very onset, Kelli struggled. And I understand this, Your Honor, as I present to the court. This is not made it crystal clear to Kelli in every session that we never lose sight of the fact that two families lives have been devastatingly changed forever due to this tragedy. We can never lose sight that the work that she has to do to understand this tragedy is going to be difficult and continuous. So with that being said, Kelli and I engage in various therapeutic modalities from CBT, DBT, prolonged exposure therapy to understand the gravity of this situation. Kelli struggled at first due to the overwhelming emotions that she would experience and being re-traumatized by this event, as well as I'm sure the Dillman and Burns family have as well. This incident was so tragic on so many levels. As we got into deeper therapy, I had to take time to step back because of Kelli's health and her mental health wellness, having suicidal ideations and things of that nature. So I had to modify that. In the last few sessions, as she got closer to, obviously, this moment forthcoming, again, the treatment focused on understanding the lives of the families who have been impacted, as well as her very own family. And we've made progress. The work, by no means is it finished, by no means is it complete. This is a intentional healing process of rebuilding across the lifespan. This moment is forever etched and emblazoned in so many lives, if you heard the testimony this morning, as well as Ms. Anderson's. Kelli has made progress. She has made progress. And she continues to do the work. She continued to do the work, no matter how difficult it was. And it was very difficult.
In your sessions with Kelli, has she been remorseful about her actions?
Yes. There are times when I felt it would behoove both of us to terminate the session, because it was just, when you have a flooding of trauma that suffuses the body, we have heard of fight, flight, or freeze, but there's three other options that a lot of individuals are not aware of. It's feign, fawn, and faint. When a person cannot leave a stressful situation, then the body, the mind, engages in a process called psychic anesthesia, where it disassociates. At times, Kelli, I could see her being physically present in our session, but I knew that mentally she was not there. So we had to disengage, and when she was able to come back in the moment, just the flooding of just tears and inability to articulate those visceral feelings that she was and emotions that she was experiencing, it was palpable. So the remorse was there, the wishing that she could do things differently was present. So it was a very, very polarizing moment on more than one occasion.
Are you the same Kevin Scott who's the director of an organization called the Crisis Peer?
Yes, I am.
Is that the capacity in which you've been meeting with Kelli?
Yes, it is.
Is there anything else you'd like the court to know about your interactions with Kelli throughout the past few years?
No, the only thing that, in addition to what I've just said, is the fact that when this was first brought to my attention, a mutual friend of ours, who again attended school with us, reached out to me because I specialize in this, and based on my research and work regarding this very, very tragic situation, I understood that there's going to be no words that are going to be appropriate. There's going to be nothing that we can do to change it. And I told Kelli that in order for you to get through this, you're going to have to be honest, you're going to have to be transparent, and the most difficult part about this is eventually you're going to have to come to some acceptance and accountability of your actions and the devastation they caused, as painful as it may be, because that is the only way that you can start your healing and hopefully allow those who've been impacted by your actions to somehow heal as well. It cannot be done with words. It has to be with intentional action and engagement, and Kelli has started that process.
So she was receptive to that approach. It
Absolutely.
did resonate with her.
Absolutely.
How did you know Kiana Burns?
She was my younger sister.
If you could tell the court a little bit about how these events have affected you.
Well, before Kiana was killed, I was largely independent. I was married, living on my own. My entire adult life, I've worked as a veterinary nurse. And at the time Kiana was killed, I was working on my bachelor's degree in wildlife biology. Since all of this has happened, I've been forced to become a stay-at-home parent to Kiana's youngest child. I've also not been able to finish my degree because of the time demands of having 4 children in the house. I've also been forced to move back in with my mother at 35 years old because neither one of us have the energy to raise all of Kiana's children alone. So essentially, the actions of Kelli Anderson have turned my life completely upside down in every way.
To this court and the Honorable Judge Charles Miller, and to the families of Dr. Brian Dillman and Mrs. Kiana Burns. There are no words that can truly capture the sorrow I carry or of the weight of what I've done. On the day of the tragic incident that took the lives of your beloved Brian and Kiana, I experienced a medical emergency behind the wheel. But that fact does not in any way excuse, minimize, or lessen our responsibility. I take full and unequivocal accountability for the irreversible pain, loss, and trauma I have caused your families. This tragedy has shattered lives. It has changed the trajectory of your families forever, and I am painfully aware that it is because of my actions. These were not just lives lost. These were vibrant, loving people who were deeply cherished. A gifted physician, a devoted mother, a daughter, father, friend, and so much more. And I took them from you. That is a truth that I must live with for the rest of my life. To Brian Dillman's widow, Miss Erin Hedges, to your daughter, Eleanor, and to his parents, Peggy and Scott Dillman. To Kiana Burns' mother, to nieces Gatlin, and 4 beautiful children. No words can ever express how truly sorry I am for taking someone from you. that I know each of you love deeply and dearly in your own special way. From the depth of my heart and soul, I apologize for the immeasurable pain and grief that I have inflicted upon you all. I know that apologies cannot heal the wounds I've caused, and that there is no undoing what has been done. But please know that not a single day passes without me carrying the sorrow, the guilt, the burden of knowing that I took away people who were the very heart of their lives. To my own family, friends, and support network, I offer my deepest and most sincere gratitude for your compassion in that time, when I do not deserve it. And I extend my heartfelt apologies for the anguish and shame that my actions have caused you. I recognize that this pain ripples far and wide, but none more so than to the Dillman and Burns family. With utmost respect, I am so deeply sorry. I recognize that no words, no gesture, no amount of sorrow can restore what has been lost or bring comfort to the depth of the grief you are forced to carry. I do not presume to share in your pain, nor do I claim to understand the unique and personal ways in which each of you must now move forward without your loved ones. What I can say with complete sincerity is that I accept full responsibility for the devastation of my actions for the rest of my life. I am committed to facing the consequences of my actions and to honoring the memories of Dr. Brian Dillman, Mrs. Kiana Burns, through accountability, humility, and a lifelong commitment to doing better. With profound sorrow and deepest sympathy, I, Kelli Anderson.
I guess to begin, the state would recognize and concede that these two cases present unique circumstances for the court, for the legal system to consider. And we'd also concede that many of the specifically enumerated statutory aggravators don't apply to Kelli Anderson. But I believe it's within the court's purview to consider the nature and circumstances of these offenses. And so I want to discuss the nature and circumstance of these offenses. Addressing these two homicides in the order that they occurred, starting with the accident of May 19th. Defendant crossed over incoming traffic, went off the road onto the sidewalk, clipped a utility pole, and then struck Dr. Dillman, killing Brian Dillman. She was speeding up at the time of impact. And this homicide of Dr. Dillman is absolutely tragic, first and foremost, for the Dillman family, who you've heard from today, and who you've gotten to know a little bit because of the impact letters that were submitted to the court. But it's also a tragedy to the community. Dr. Dillman was a longtime ER doctor and also a researcher at Eli Lilly. And the family of Dr. Dillman and the community are deprived of his contributions going forward. The nature and circumstances of the second accident are especially outrageous, because 3 weeks after killing Dr. Dillman, the defendant made the choice to get back behind the wheel of a vehicle and drive again. And this time, she was heading on Keystone Avenue. 61 miles per hour, 3 seconds before the crash, and 68 miles per hour at the time of impact. She was speeding up at the time that she struck Kiana Burns. She was traveling with such incredible velocity that she caused a chain reaction accident that ultimately damaged 8 vehicles and led to the tragic death of Kiana Burns. It's by the grace of God that none of Ms. Burns' children were in the car at the time of this accident. This accident, this homicide, obviously robbed the Burns family of the opportunity to spend the rest of their lives with Kiana. As you've just heard, the state concedes that the defendant does in fact have a seizure disorder, and that she was cleared to drive after the first accident. But having reviewed hundreds of pages of the defendant's medical records, I can confidently say that the defendant had had these conditions for years. The defendant had intimate personal knowledge of the consequence of these conditions. The defendant knew that the consequence of these conditions is that she would lose consciousness without her control and without notice. And armed with that knowledge, the defendant armed herself with a 1,000-pound vehicle and let loose upon our community, come what may. And that is outrageous to do once. That is outrageous to do ever. It is unspeakably outrageous to do that a second time, 3 weeks after killing somebody. And I would submit that that's an act of selfishness on the part of the defendant. I would submit it boils down to nothing more than it's more convenient to drive yourself than to get a ride. And that's an nature and circumstance that I find to be especially aggravating in this case. She engaged in profoundly dangerous conduct, and this is the terrible but obvious consequence of that conduct. As Your Honor is very well aware, these two cases have pended in this court for an extremely long period of time because they are such unique circumstances. They present some novel legal issues. Some of those issues required an appeal to the Indiana Court of Appeals. During that time, the defendant has accrued pretrial credit time because she's been placed on pretrial home detention after she posted bond in each of these cases. And that credit time will have to be applied to any sentence that Your Honor gives her today. The terms of this plea agreement were negotiated with defense, and the state has been in regular contact with the next of kin for each of these families about the plea, about the terms, and about the agreement. And while I think on one hand it is fair to say, and I believe you've heard it today, Judge, on one hand these families absolutely believe it would be appropriate for Ms. Anderson to receive a much more severe sentence. It's also true that these families have a countervailing concern in avoiding what would be a terribly challenging trial, heartbreaking trial to go through, not once, but twice. And so the parties have entered a plea agreement that does limit the defendant's ultimate exposure. And I would note for the record that the defendant on cause ending 016321 has 1,316 days of credit, and in cause ending 009195, she has 984 days of credit. I want to move now and talk a little bit about the defendant's driving privileges because that's obviously one of the most important aspects of this entire agreement. Under the terms of this agreement, she will suffer a driver's license suspension for 6 years, which is the maximum available for a level 5 felony, which is what she's being convicted of here. In addition, and separate and apart from that suspension, these two convictions will make the defendant a habitual traffic violator, and so she will have a separate 10-year suspension by virtue of being HTV. And as to that particular issue, in consultation with the BMV, there is some specific information that will need to be put into the sentencing abstract in this case afterwards. I'll follow up with court staff immediately after to provide all that information. In addition to those two suspensions, the 6 years that flows from this case and the 10 years that flows from the defendant being a habitual traffic violator, the defendant currently also has what I'll colloquially call a medical suspension. Okay? She was reported to the BMV after these accidents, and she cannot receive a valid license under that suspension unless and until she provides medical documentation to the BMV, and they would ultimately conduct a review of her condition to decide whether to terminate her driving rights or whether she would be allowed to have her driving rights back. Moving to the final request, Judge, the state is asking for the maximum sentence available under the terms of this plea agreement, which is 3 years of short-term imprisonment, followed by 3 years suspended with 3 years to be served on full reporting or monitored probation. As terms of her probation, obviously, we would ask that she be not allowed to drive. That's in effect to the suspensions. And we would also ask that she complete the Thinking for a Change behavior modification course as a term of her probation. Nothing further, Judge.
Before we begin, Mr. Jared, the 10-year license suspension, would that be consecutive to any suspension this court imposes?
It would not be consecutive, Judge. It would start upon, at the point that the B&B receives all the necessary paperwork, so it would not be consecutive.
Final word, Mr. Jared.
Thank you, Your Honor. Judge, you have before you a defendant who was 55 years old the first time she came into contact with the criminal justice system. She's a high school graduate. She earned an associate's degree. She doesn't drink. She's never done drugs. She had long-term employment at the time of the first crash. That's a cluster of qualities that doesn't show up very often in rooms like this. But we're not here because of those good qualities. We're here because Ms. Anderson suffers from a medical condition or a combination of medical conditions that can strike without warning. And strike they did with catastrophic and tragic results. Kelli sought treatment for these conditions for years, consulting with neurologists and allergists. And after the crash that killed Dr. Dillman, she listened to the doctor who saw her at St. Vincent, who told her she shouldn't drive until she talks to her neurologist. She listened to her neurologist, who told her that she was, quote, clear to drive without restriction, end quote, on June 1st. The crash that killed Kiana Burns happened a week later. After she was charged, she listened to this court when she was told that she was not allowed to drive while she was out of her mind. And that gets to the heart of things. It seems that the only thing in Ms. Anderson's life that contributes to her committing crimes is getting behind the wheel of an automobile. It's not because she's too impatient to stop at a red light or aggressively weaving in and out of traffic for the thrill of it. It's because she can pass out or have a seizure and cause terrible situations like these. All that's required for rehabilitation is to keep Ms. Anderson from driving. And that's been accomplished not only by the legal system, I think, but on a personal level. As the state mentioned, her license is currently revoked. It'll be a felony for her to drive after this hearing is over. That situation seems to have resolved itself. I'd like to briefly address the statutory considerations for sentencing. None of the listed aggravators apply. I think the closest analog would be the argument that the short amount of time between the crashes is akin to a criminal history, a history of criminal behavior. Again, we cannot overlook the fact that Kelli saw her longtime neurologist between these two crashes, and he cleared her to drive. Which brings me to the mitigators. First, crime is the result of circumstances unlikely to recur. I think it has been made painfully clear to Ms. Anderson at this point that nothing good can come of her getting behind the wheel of an automobile. Second, Dr. Puzio's advice is clearing her to drive without restriction constitutes substantial grounds tending to excuse or justify the second crash. Third, she has no history of delinquency or criminal activity. The fourth factor is that she is likely to respond affirmatively to probation or short-term imprisonment. She's been on home detention since June of 2022 there was a violation filed in error as a violation, but it was a memorandum. No violations have been filed alleging that she has violated the conditions of her pretrial release. And this court's aware that for somebody to do that for nearly 3 years is uncommon. The fifth is that the character and attitude of the person indicate that she's unlikely to commit another crime. These are charges of recklessness. She didn't seek out a victim. These aren't crimes of passion, they're not even crimes of opportunity. If anything, in this city, there's something kind of approaching necessity. Not that that excuses or justifies Ms. Anderson's actions, but it's very difficult to thrive in this city without the ability to drive a car. Finally, I believe imprisonment would result in undue hardship to Ms. Anderson. The length of the sentence that the court is working with means that she may not even get out of the reception diagnostic center if she was sentenced to prison. She may not even make it to the reception diagnostic center. With transportation between the jail and the prisons, she may end up serving that entire sentence at the adult detention center. And I would remind the court that when she was arrested, after the charges were filed on the first crash, she was not able to be brought to court for her initial hearing as it was scheduled due to her medical conditions. As far as the non-statutory mitigators, she has taken responsibility for her actions. It's taken some time. As the state mentioned, there have been some legal delays in the case due to the unique nature of these facts. And also, as Dr. Scott testified, realizations like that don't always happen quickly. Sometimes it takes time. She's also remorseful, which the court and the families heard when she had the opportunity for allocution. So all that being said, our request for sentencing is that if the court does reach the cap of 3 years on the executed time, that she be allowed to serve the remainder of that sentence on home detention. She's proven she can follow the court's orders and successfully complete a sentence of that nature. As far as additional terms and conditions of probation, I think the state made a good suggestion about the thinking for a change class. I also think Ms. Anderson would benefit from a mental health evaluation with probation to see if the treatment they recommend is in alignment with the treatment she's been receiving from Dr. Scott. Thank you.
Counsel, why are we talking about imprisonment if pursuant to this plea, the counts are to be served concurrently and she has 1,372 days on one count?
On the other count, she has 984 days.
Okay, if they're to be served concurrently, then how is that possible?
My understanding is that since she has not reached the maximum sentence on the cause in the 0190-195, that the court could impose an additional traditional executed sentence.
Is that your understanding?
Absolutely, Judge.
And one other question for the parties. I seem to recall during the issues related to the grand jury testimony that Dr. Puzio in fact testified before the grand jury that Ms. Anderson had not told him that this was a fatal accident, and if he had known that, that would have changed his recommendation. Is that not true?
That is true, Judge.
That is hard. I guess in the grand jury, I think that's
The
what he
sworn
said.
testimony he gave before the grand jury, did he not say that?
I believe that's correct.
And there is no mention of a fatal accident in this Exhibit A.
In that, no. But there is reference to it being a serious accident.
Court does note, as it is required to, the defendant's lack of criminal history in this matter. Court does decline to consider as a mitigator, crime being a result of circumstances unlikely to occur, or defendant being unlikely to commit another crime. It doesn't get to happen twice, and the court still gets to consider those mitigators. Court further declines to consider substantial grounds tending to excuse or justify a crime. The defense of necessity is not a defense in this case, and one has adequate information that getting behind the wheel is a very bad idea. I want to thank the attorneys for their advocacy and those who submitted testimony and letters. This court is to decide cases on the law and the facts. I'm not to make up a remedy or a sentence just because of how I feel about a particular matter. And I say that to say this: what you did is rightfully classified under the laws of this state as reckless homicide, a level 5 felony. The second lowest level of felony in the state. And the willful damage that you caused the Dillman and Gatling Burns family does not appear in any way adequate for this level of offense. But that's what the legislature has deemed us to be, and I am bound by that. And it is widely acknowledged that this city suffers from a pedestrian crisis, and I see evidence of that in this court constantly. Not only do those walking down the streets of this city have issues facing hostile infrastructure, lack of crosswalks, sidewalks, and other matters, but now they have to worry about someone like you. Simply, an individual simply walking down the sidewalk, and you, despite a history of accidents, even before the first one, running off onto the sidewalk and killing an individual. And the fact that you did it again after this, you clearly knew this was the wrong thing to do. And you continue to drive. You continue to make justifications and excuses why you should drive. You have cost our community an emergency room physician and a young mother full of promise. And that will reverberate through this city in ways that cannot be measured for decades. But once again, I am bound by the legislature's determination here. And I am going to give you the maximum sentence I can, because what you did deserves DOC time. And I'm going to give you the maximum probation time I can, because I need to ensure that you, as a condition of probation, do not drive while you're under my supervision. I have a community caretaking function here, and the last thing we need is you on the road. I want to make myself crystal clear in that matter. If you are caught driving while on probation in this matter, probation is going to send me a request for a warrant. I'm going to take you into custody, and I'm going to have a hearing. And if it is determined that you are driving while under my supervision, I will send you to the Department of Correction again. Do I make myself clear? Judgment of convictions having already been entered, count one for each cause. court has sentenced the defendant for each count to 1,095 days in the Department of Correction. Credit as stipulated by the parties for the case ending in 321 of 1,372 days. For the case ending in 195, 984 days. The balance shall be served on probation, the 6 years, standard terms and conditions. I'm going to recommend thanking for a change or continued treatment that she's undergoing now, her choice. Mental health evaluation and treatment, 6-year license suspension. I do have concerns that even after you complete this sentence, you will consider continue to drive. The state is required within 14 days to send a letter to the Commissioner of the Bureau of Motor Vehicles containing the judgment of this court, the probable cause affidavits, and ask what administrative rules can be applied to Ms. Anderson and to file that with this court regarding license suspension to ensure that she's medically cleared. Sounds like they've already are mostly there on that. I want it made part of the file. Nothing I say or do today will take back the loss that you have felt. I'm sorry for your loss. I hope this can begin the journey of healing and closure. The defendant is remanded to the custody of the Department of Correction. Any questions about this court's order?
No, Your Honor.
Good luck, Ms. Anderson.